Good afternoon. It is 1:30 and I will convene the February 19th meeting of the Board of Adjustment. We are here today to hear special exemptions, variances to the zoning code, oil and gas related cases, and appeals from the decision of the director. I would like to ask the audience if they would please silence all cell phones at this time. Also, I want to make a comment. We have 4 members today instead of 5. A motion carries by 3 votes. So if that changes anyone from wanting to have a continuance or anything of that nature, please take that into consideration. That takes us to agenda item number 2, where we will receive the minutes of the February 5th meeting. But before we entertain that motion, I understand one of the members would like to amplify something. Ms. Powers?
I did just want to make a comment with respect to item number 4, on which I voted no. I wanted the minutes to reflect that the basis of that vote for me was that I wasn't sure that the Board of Adjustment was really the right place to solve that problem, that really I thought perhaps it had more to do with modification of the underlying PUD, and that was more of a planning commission, city council.
I also voted no on that, and I'd like the minutes to reflect that was the rationale for my vote.
You want that reflected in the minutes? Okay.
So will we vote on them after?
With that amendment to the order, I'll move to approve it.
Okay, we have a motion to approval.
Second.
And a second. Please cast your vote. Motion carries. Continuances and withdrawals by staff. Kathy?
We have one today. Item number 1, case number 13994, is requesting a continuance to April 16th.
Okay. Are there any requests for continuances by members of the public?
Can I ask why, I had already made a note to myself about why this had been continued previously. Is there some issue about it that we need to be aware of, or is it just a...
They have new legal counsel.
Okay.
Okay. So we have one continuance by any members of the public that wish for a continuance. Yes, sir. Come forward.
Ryan Ford, Cube Storage.
Okay. Agenda item number 5, correct?
Yes, sir.
And when would you like your case continued to?
Next session.
Next session, which will be the 5th. Okay. So we have 2 continuances, agenda item number 1 and agenda item number 5.
Is there anybody else who's here today to be heard on item number 5?
Yes, there are 2 people that will be heard on item number 5 that have registered. That item is being continued to the 5th. Do they have an objection to that?
No objection.
Thank you. There being no objection, I'd entertain a motion to continue those items.
I'd move to continue those items.
Okay.
Second.
All in favor? Okay, the motion carries. Agenda number item 1 and 5 are continued to March the 5th. Would you call the first case, please?
Item number 2, case number 13991, request of Blue Sky Outdoor Advertising for a variance to the sign regulations located at 12003 North I-35 Service Road.
Good afternoon. David Box, 522 Colcord Drive. Here on behalf of the applicant, and also with me is Trent Lindmark, who is the applicant. I'll let this be passed out. What you are receiving are various orders memorializing granting of a variance by the Board of Adjustment over the last several years on this exact issue. What we're dealing with is a variance request to the spacing requirement between billboards. Several years ago, the city of Oklahoma City changed their spacing requirements from 1,000 feet, from 1,000 feet to 1,200 feet, while all the other municipalities and ODOT still maintains a 1,000-foot spacing requirement. So it's created this unique circumstance in Oklahoma City where there are many existing billboards that are still legally permitted by ODOT, and in other cities would be permissible, but because of the city's requirements, they become nonconforming. So what we're asking for today is nothing more than a spacing variance. Now, when we look at these, it's important to understand why we need the variance in the first place. And that all goes back to the way the building permit staff interprets the code. If we could install what we're requesting on the pole that's already there, that's not considered a new sign. But because the pole has to come down, staff considers that a new sign, and that's what triggers the variance. What we're asking for in size is compliant with the code. What we're asking for in height is compliant with the code. We're modernizing and upgrading the billboard. But because of the sign pole being older, it will need a new pole in order to support what we're going to be installing. And I do think it's important that we look at a handful of these variances in light of the protest letter that you've received. And we've read through them, and the protest boils down to nothing more than a fear of competition. And Lamar routinely protests items like this. And if you look through these variances, specifically Exhibit number 3.
Mr. Chairman, I'm going to object to this material being admitted into the record. I feel like if there's one particular thing that every variance has to show it's that it's peculiar to this particular piece of property. I don't see how any previous ruling on a variance on another piece of property elsewhere can serve as any kind of a precedent to our considerations here. I just don't think this is relevant information to our deliberations.
There's no record that I'm seeking admission. These are demonstrative exhibits. There's no precedential effect. I'm simply showing these so the board can have an understanding.
Let me ask, David, hold
Yes,
on.
sir.
Let me ask a question. I was told in the past, I just want to be sure this is true, that when we're given exhibits, it's up to each board member to place what level of credibility they give to them, and it's not actually being admitted to the record. Is that correct?
Yep, you are free to consider these exhibits as you would like, and each individual board member can weigh them as they would like.
So, Janice, they're not a part of the record, so if you choose to disregard them as a vote, I believe what she's saying, that's your own choice, correct?
Since they are being presented, they are part of the record, but each board member can individually weigh them as they see fit.
Is your objection to them being admitted to the record, period?
We have the right to put anything in the record we want. It's a zoning case. I mean, anything we submit to staff is considered part of the record. There's no admissibility standards like we're in district court. So I don't know that there's grounds or a mechanism to object.
Is that accurate? Do we have an actual written policy or case law on this subject?
He's free to introduce whatever he thinks is relevant to his case, and then each board member can determine for themselves whether or not they want to consider what's being presented.
What I've seen in the past, and correct me if I'm wrong, Laura, is that they can offer exhibits and they become a part of the record for purposes of appeal to the district court. What relevance or weight we place on them is an individual determination.
That is correct.
Right, because I know there have been times in the past where there's been some argument as to whether newspaper articles, et cetera, should be admitted, and that is admitted, but it is at the discretion of the board members as to what degree of credibility they place on them. So I think that being said, that he's allowed to admit it, and you can use your own discretion as to what you want to place on it in effect to the ruling.
And it'd be no different, Ms. Powers, if we were at the Planning Commission and a neighbor submitted a letter that said, this is going to kill all the children in the neighborhood and lower my property value. You're free to believe it or not believe it, but it's a part of the record. If we look at Exhibit number 3, it's similar to what we've got here. Representatives of Lamar appeared to object and protest, again, because competition. And if we look at number 4, it is an identical scenario in which we are not increasing the number of signs permitted along this stretch of highway. The net effect will be a wash. There's a billboard there now. The billboard can remain. All we're seeking to do is modernize it and do everything within the code. But if we look at Exhibit 4 and the second to last page, when you look at the favorable condition, it's the same thing we've got here. There will not be an increase in the number of signs, only the distance between the signs. And finally, number 5 is a Lamar application for this exact variance. It was slightly different in that it involved an ODOT taking. Now, in your packet, you do have an image of our sign that you can see. And as I said, it's important to note that what we're seeking is not an additional billboard. What we're seeking is not a billboard that doesn't meet the code requirements. All we're seeking is to put a billboard back in the exact same spot where this billboard currently resides, just in a manner that is more consistent with the modern technology that everybody's become more accustomed to seeing now. So I think when we look at the hardship, it is certainly unique, in my opinion, that the position that the removal of a pole is what triggers this is a new sign. So if we, I guess, could structurally shore up this pole, we wouldn't need to be here. But there's a staff interpretation that requires, if the pole is changed, that we've got to get a variance. So I certainly believe that's unique. I certainly believe that creates a hardship. There will be no detriment to the public good, and as it relates to that, I think it's worth looking at exhibit number 5, that being Lamar's application before this board in 2013. And when we look at what Lamar said, and this is on page 2 of the staff report contained within that exhibit 5, and I quote, "Granting of the variance will not cause detriment to the public good or impair the purposes or intent of the ordinance or the comprehensive plan, as Lamar is not increasing the number of signs in the immediate area." And that's exactly what we have here. We're not increasing the number of signs. It's the same number of signs that will remain.
Tell me
like I
where
said.
you're reading from again. I had trouble getting to.
Yes, sir. Page 2 of the staff report, which is contained within exhibit 5. It's page 5 overall in exhibit 5. So with that, this is truly a unique situation, and this is why the variance process is in place. And while these aren't precedential, I think it's important to see how the board traditionally has looked at these. And it's this change in spacing and the way that the pole is interpreted by staff that triggers the need for this. But there's going to be a net wash of number of signs. There won't be an increase of signs. And if it's denied, the sign will remain. It'll just be a older, rickety, outdated billboard. But it won't have any impact on the number of signs. And with that, we'd be happy to answer any questions you might have.
David?
Yes, sir.
And I'm talking from the report that you cited as Exhibit 5.
Yes, sir.
The unfavorable condition cited by staff was the fact that the city of Oklahoma City decided to make their regulation more stringent than ODOT by 200 feet.
Correct.
And you're asking for a variance of the spacing of 185 feet.
Correct.
So if the intent of the city was to make, normally, okay, a couple hundred feet plus or minus 10%, we would not, we would be, in my mind, I'm a little bit more lenient when it's a 1 foot, on a 15-foot setback, which is 8%. But it seems to me that you're asking for almost the exact number of feet that the city specifically was trying to tighten around. So they went from 1,000 feet to 1,200 feet for a specific purpose, and you're asking for 185 feet, and you're saying, well, the ODOT regulation is less stringent than the city of Oklahoma City, and I believe the intent of that was to be more stringent.
That's correct. And when you look at almost all of these, that's the situation. Because you've got an existing billboard that is likely 1,000 feet, and now they're needing approximately 200-foot variance because it's an existing as it was permitted at the time constructed when the city was at 1,000 feet. So that's how all of these come about.
So everything coming forward,
New billboards coming forward.
with new PUDs would have the 1,200 feet restriction already in place, and we wouldn't be coming back to this board.
Right.
Okay.
As you go forward on a new billboard on any of the interstates or highways around the city, it would be 1,000 feet. The reason why we're here and why it's unique and warrants a variance in our opinion is because it's an existing sign. that was legally permitted the day it was built and is still legally permitted pursuant to ODOT. And the only reason it's a, quote, new sign is because staff takes a position on the pole. But it's not a new sign in terms of when you're driving by, it's going to be a wholly new +1 billboard on the highway. It's the same sign, just new pole, new face.
One more new face, though, because you're going to have a sign on each side.
We can have a sign on each side now.
Okay.
Yeah. Yeah, there is no variance to square footage. There's no variance to height. We do have a small setback variance, but that's to allow the other existing buildings to not be blocked by our sign, and it's minimal.
I was going to say it's also the fact that the sign is larger than the existing sign, that it's considered a new sign as well.
Correct. But still within the confines of zoning. It's
Is it almost double?
It's just, yes, I think it's slightly less than double. I think it's slightly less than double.
Mr. Chairman, I can't support this request for variance, and although the applicant indicates that he's really only asking for this one tiny little thing, in my reading, we're actually looking at three separate things. An encroachment into the front yard setback, a spacing issue, and also another sign, and another side to the sign, and it's going to become EMD. The fact that they have to make these upgrades in order for that to happen is why it's a new sign. There's no way in which this is in any universe unique. As Mr. Boggs said himself, there are many existing boards in this exact situation all over Oklahoma City. If you look at the unfavorable considerations of the staff report, it says that it's the intent of the ordinance that eventually nonconforming uses and structures cease or come into compliance. So how you can possibly look at that very specific intent of the ordinance and say, well, it won't matter or harm the intent of the ordinance as is required by one of the specific requirements of a variance request baffles me. The idea that you can argue that not having EMD capability is somehow a hardship really is kind of beyond the pale in my view. I can't support this, and I really feel like I can't support this.
Let me address a couple. Go ahead, Mr. Chairman.
Okay. Yeah, go ahead and address that, and then we'll take some other questions for the board, and then we'll hear. I know Mr. Hickman's here.
Yeah, a couple points. We're not seeking a variance to allow another face. We could go put up a 672 square foot face on both sides today. It would just be the big stretch vinyl that you see now. And we could change it every day if we wanted. We could change it every 2 minutes if we wanted. What the EMD allows is an extra benefit to the public. Instead of it being a big vinyl that manually has to be taken down by people, through EMD signs, you can have public service announcements. You can have silver alerts. You can have amber alerts. You can have rec alerts. So the EMD, although it allows for more advertising, it provides a benefit to the public. It allows for those public service announcements that otherwise cannot be done. But we're not, to talk about how we're increasing the size, that has no relevance to this application because we're not seeking a variance from size. And if this were denied, we could go put up another vinyl at 672 square feet. The need for the new pole is because the cage in which the EMD signs are held are different than what's necessary for those big stretch vinyl.
Just to clarify, you couldn't add the other side or go any larger today without the variance.
Well,
Because it's non-conforming, you can't go larger. You can upgrade the existing sign to digital, but just the size that's there now on the one side.
I
Couldn't have
think
the
that
back
there
and
would
couldn't
be.
go larger.
Well, that could be addressed another day. I don't know that I agree with that.
Yeah.
Real quick, can you address Ms. Powers' concern that the undue hardship aspect of this is not met in the sense of something that's not financial in nature?
The hardship isn't that it's a financial issue. The hardship is, I think, the interpretation of the code. I mean, the trigger being a new pole has to be in place, I think creates a hardship on my client. Because somebody might come in a few years that has a different position. Because you could argue that every time you take a vinyl down and put up a new vinyl, that's a new sign. You know, it was Mathis Brothers, now it's Bob Mills. That's a new sign. Staff doesn't interpret it like that. But if they did, that'd be a hardship. The hardship isn't financial. The hardship is the interpretation of the code.
Mathis Brothers and Bob Mills thanks you for the advertising.
Any other comments for Mr. Boggs? Mr. Hickman?
My leg fell asleep.
Well, it's easy to do with the questions this group asks.
William Hickman, 5808 Santa Fe Drive, Oklahoma City. Represent Lamar Outdoor Advertising. I think you hopefully have seen the protest letter that we submitted. I'm a little perplexed. I looked online at the a case report today, and I didn't see any of these exhibits that were referring to Lamar, and I don't think Lamar is a party to the matter, so I was surprised to hear so much about Lamar's name. So I can't speak to all of those exhibits that were presented, but exhibit number 5 was one that seemed to be intensified in discussion and part of the reliance on the applicant. And there's a fundamental key distinction on that particular application was that was a part of a ODOT taking. And so there was actually a 2-for-1. 2 signs went down, one that was taken, one that was there at that existing location that went down, and then one sign went back up. So there's unless they're going to propose to take down another sign, take 2 signs down and put one back up, I think that was a part of the consideration by the board at that time, was it being a part of an ODOT taking, and then in a sense 2 signs came down, the one that was taken, the existing sign, and then only 1 sign went back. So it was a reduction in the total number of signs in the inventory in the city of Oklahoma City. Just wanted to clarify that since I was aware of that particular case since I was involved in it. And I don't think it was made clear to you that that was to me, a very major distinction. But anyway, with regard to our protest letter, I just wanted to clarify a couple of things. Lamar's not protesting them putting a digital sign, like I think JJ said, on the existing face that's there, the size that they have. We understand that that's what is allowed and what they could do. We do agree with JJ that if they do increase the size of that face, which they're proposing to do, if they put a backside on that face, I think we all understand that a non-conforming use, you cannot increase the degree of non-conformity. You can't put lights on if it doesn't have lights. You can't make it bigger if it's not, than the size it is right now. It doesn't matter if you're talking about a billboard or a building. What they want to do is increasing the degree of non-conformity. The way they avoid that is by getting a variance on the spacing, which then makes it a legal location under the new standards. So you're doing away with the non-conforming restrictions by getting a use variance for the spacing, which then would make that sign a legal location that could have anything done to it that a legal location could have done to it, as far as the size of the face, those things. So I do think it needs to be clear that the current face, I think it's a 12 by 28, is all that they could have without the variance on the spacing. And they could make it a 12 by 28 digital, which we would not be up here protesting. All that being said, as has already been articulated, the point of things being non-conforming is for them to eventually become into compliance or to go away. I think another important point I want to make, I'm glad that I was here, is that their hardship is, I think I wrote it down a couple times, the interpretation of the code. Now, I know usually if I get up here and protest and you guys say, well, Mr. Hickman, when you're back here with your client, we'll hear that case on its own merits. But when you make a ruling based on hardship being an interpretation of the code, then I'm going to be back up here saying, you just now clarified your interpretation on behalf of the city of Oklahoma City of your sign ordinance, And when we come back up here with all of our non-conforming locations wanting an ordinance, wanting a variance because the hardship is created by the interpretation of the ordinance, i.e. the pole, then I would expect that you would honor that same new interpretation of the city sign code to allow for us to then do the same kind of thing for all of our non-conforming structures. I did not intend to make that statement I just made to you when I showed up here today, but when I heard the basis for their hardship, I felt compelled, knowing that normally I wouldn't have said that because I know what you would have said back to me because I've done this enough times. But I do want to make it clear, if their hardship is the interpretation of the code, which is what they have said, then that interpretation should be the same for everybody in the industry. And if the hardship is going to be that now way the city interprets a new sign pole from a non-conforming structure, then that should be the same for everybody. I mean, in a sense, I think we're kind of recrafting or reinterpreting the ordinance. And it's your decision to do that. I'm not saying that you can't, and not saying that you shouldn't. I just want it to be clear on the record that if you do find a hardship based on interpretation of the ordinance, I do think that that is a bit of a different type of a basis and something that then should be also allowed to be carried forward into other potential cases for grounds for a variance for a non-conforming structure. Because I just wanted to make it clear, and JJ can correct me if I say anything that's incorrect, that we're not talking about them putting up the same sign. This is going to be a new billboard. It's going to be a bigger billboard. It's going to have digital on it. So it's not the same sign. Like I said before, if they were simply putting digital on the existing sign, the 12 by 28, we wouldn't be here protesting. And my client's only concern is making sure that the rules are applied evenly to everybody and we know what those rules are. And when the rules are being changed through asking you to interpret the code differently, then we want to make sure that we're aware of that and we have our opportunity to make those statements. And the last thing I want to mention is, I haven't seen the other exhibits they presented. I wouldn't say that Lamar routinely protests. We do want to ensure that things are interpreted appropriately and everybody is treated the same way. I don't think there's been a protest that Lamar has brought forward that wasn't founded properly or didn't have merit to the benefit to the board. I think that's all I have to say right now.
Questions for Mr.
Anybody have any
Hickman?
questions?
I had a question of JJ. The mayor's billboard advisory committee, when they made this decision to go to 1,200 feet, increasing from 1,000, what was the thought process behind that, if you remember?
Just to decrease the number of potential locations for billboards along the highway.
Good.
Mr. Chairman, I guess my parting comment on this application is that I think it's just simply a bridge too far. The whole purpose of the designation of a non-conforming use is to provide some measure of relief to properties that are caught out by changes in the ordinance. This applicant currently has the benefit of that non-conforming use status on the sign, but the conditions under which that non-conforming use designation are granted very specifically prohibit the expansion or enlargement or enhancement or whatever other word you want to use to fill in that blank of that use. And that's what they're seeking to do here by these variance requests, and I just cannot support them.
I've heard two different things I want to get some clarity on from somebody. Can they pull a permit and add a backside to that sign and it be still a non-conforming use?
No. They can pull a permit to make the existing sign digital on the same
existing
pole.
face.
On the same pole, same size, one side.
Okay. Councilor Box?
Yeah.
In the letter that Mr. Hickman submitted to the board, it says that Blue Sky acquired its interest in the sign knowing that it was non-conforming. Can you comment on that?
Well, they acquired the interest in the sign after, obviously, the ordinance had gone into effect, like any other billboard company. But I think they acquired their right knowing that if the time was right and the opportunity was there to upgrade and modernize it, as many other billboard companies have done, that it would do it. One of the other interesting, unique factors is the way ODOT looks at this. ODOT looks at this as the exact same sign. There's no new permit. It's the same permit number. It's the same sign for ODOT. Now, as JJ said, the intent of the ordinance was to prohibit additional new signs and the number of additional new signs. This is, depending on how you interpret it, it's the same sign. There will be a billboard on this spot. It's just, do we want a modern, upgraded billboard or what we've got now? But it's not a new billboard.
Any other questions?
Mr. Chairman?
I think Mr. Hickman wants to. Do you have another point? Okay. Go ahead, Jim.
I'm going to move for denial.
We have a motion for denial.
I do not believe that the application meets the statutory requirements.
I'm going to second the motion, but I'm going to put this comment out there because people seem to be putting their own comments on this. I'm really bothered by the fact that the city has a right to come in and amend its ordinances to protect the interests that it thinks are important. And whatever reasons those are, they're not for us to sort of elaborate on here. But what you've done is you've essentially given people the ability, and in this instance, the reason I'm seconding Ms. Powers' motion is because the sign was acquired when it was non-conforming. But you run the risk of having these companies out here who have invested an awful lot of money in putting this stuff up, and then they come up to having to get an adjustment to their sign to stay competitive. And if they fall within this new ordinance, this ordinance adjustment, it's going to compromise that ability. And whether or not that classifies as a hardship or we care to interpret the code as Mr. Hickman both fears and frankly would love to have, which is that the ordinance itself is a hardship, the fact remains that I'm really bothered by that potential. So with that notation, I suppose I'll second Ms. Powers' motion.
So what you're talking about is just competitive cost.
I'm talking about competitive cost, but how many billboards out there, I wish I had the information, how many billboards out there are less than 1,200 feet apart now and are going to face this because what's happening, driving a highway in America, what's happening is all these billboards that are not electronic can't compete. Drive by this billboard out there. It is, and look at historical pictures of it. I don't think we want our highway littered with billboards that look like this one. And what we're doing when we say that we're going to enforce it that strictly is we're essentially setting ourselves up for that. So,
and let me address that point to your question on how many billboards exist. Basically, every billboard on I-40 and I-35 is 1,000 feet. And so your point is exactly on. Do we want this old rickety billboard that will remain forever, or do we want something more modern?
I just want to make it clear that when the ordinance was amended, it was done so in concert with the sign companies.
So there is a motion on the table to deny the application. Are there any further questions by members of the board? Okay. Register your votes.
Thank you.
Item number 3, case number 14012, request of Charlene O'Connor for a variance to permit a single-family residence encroaching the 50-foot platted front building line located at 15140 Edna Road.
Good afternoon.
Good afternoon. My name is Robert O'Connor, speaking for Charlene O'Connor.
State your address for purposes of the record, please.
15140 Edna Road.
Go ahead and speak to your application, sir.
We sold our house back in early October, and in the process of selling the house, it has been determined that the property line is not 50 feet back. The builder decided to build it 20 feet closer to the road, and it's holding the sale of our house up and closing.
Okay. And the residence has been there since 1975. There have been no...
Yes, sir. We had no idea this was like that.
is there anybody here to protest this case?
I don't believe so.
I'm going to make a motion to approve this.
Second.
Cast your vote. Go sell your house, sir.
Thanks, guys.
Thank you for coming. We're sorry that
Item number 4, case number 14013, request of Nawala DOP 7 LLC for a variance to the side yard setback and to allow parking and maneuvering in the public right-of-way located at 9000 South Harrow Road.
Before you start, has the city acquired like additional right-of-way here? Is that how this problem got created?
No, here's what happened. David Box, 522 Colcord Drive, also with me is Bob Gage. When, Ms. Powers, when we were going through the SPUD on this, what had happened is my client's engineers had drafted their site plan not knowing that they are a group based out of Nashville. They didn't know that it was routine in areas like this where there wasn't the additional 17 feet that the city requested it. So we drafted our application and the site plan was presented as such. Everything was set back pursuant to what the setback was, or excuse me, what the right-of-way was on that date. When we went to council, at the time you go to council, you're required to hand over your 17 feet of right-of-way that you're giving in coordination with your zoning. And so what that did was that kicked everything back 17 feet. And so that's what created the issue here. And when you look at the thing marked in red, that's showing the items that are within that right-of-way, and it's simply because of that, the issue I just described. I did have some pictures taken of the site so you could see what is in there. It's fairly minimal. Like I said, it was simply a drafting error. It was drafted pursuant to the way the right-of-way existed on that date. And then as of the date of council, when we handed over that right-of-way, everything shifted 17 feet. Now, if you're familiar with the area, if you've driven the area, I have a hard time believing that there will be a expansion of this roadway anytime soon. If staff knows of any projects, I defer to them. But obviously, if that happens, then we'll have to address the location of these. But the variance we're seeking is fairly minimal. The parking and maneuvering, I think, is just a handful of feet.
JJ, just question to his point, if the city decided to widen this road and they went out, if we grant the variance, at that point, what happens?
I don't think we would ever widen the road to the point that we would reach any of these encroachments. The only one that's in the right-of-way is...
There's no chance of encumbering the city into a condemnation.
No, the encroachment is so small that with the widening the street wouldn't come close to it.
Wouldn't it be a simple thing to just condition the variance, however unforeseeable it might be, on the fact that if the city needs the actual dirt for road expansion or for right-of-way use, that they'll have to?
I defer to the municipal council. I don't think we can do that because that's a taking. That'd be a taking, and that would be waiving them a constitutional right, correct?
I don't think you can condition a variance.
Yeah, you can't condition it on if an eminent domain issue would.
And if you look at the picture, you can see where the roadway is in that last one. And like JJ said, I can't. One, I find it hard to believe that this, is going to. There's no utilities out there, so I can't imagine they're going to need to expand it.
There's more than enough room for another traffic lane there without even getting close to the parking.
Okay.
Is there anybody here in opposition? If not, I'd make a motion to approve the variance.
Second.
We have a motion and approval. Please cast your votes.
Thank you.
Agenda item number 5 has been continued. That takes us to agenda item number 6.
Item number 6, case number 14014, appeal of William Jefferson of the decision of the Historic Preservation Commission regarding the denial of a certificate of appropriateness for fencing, new front and east side doors, new garage door, and outdoor kitchen located at 205 Northwest 32nd Street.
Is Mr. Jefferson or his representative here? There being no represented party, I think it'd be in the best interest of the applicant if we continued it. That way they didn't have to go through the process from the beginning.
I'd make a motion that we continue it to March 5th, please.
Katie, is that okay with you? Okay. We are going to continue it to March 5th. Is there a second?
Second.
All in favor? Okay, the motion passed. There are no additional items before the board, so I would entertain a motion to adjourn.
So moved.
Second.
All in favor? We are adjourned. Thank you.